Hello, everyone, and welcome to the 33rd Annual Animal Law Conference, co-presented by the Animal Legal Defense Fund and the Center for Animal Law Studies at Lewis and Clark Law School. Thank you for joining us on this virtual panel to kick off the conference. My name is Alyssa Crowell, and I'm the Law School Programs Attorney here at the Animal Legal Defense Fund, and will be moderating us through this exciting panel on global perspectives of advancing animal law. Before we get started, I would like to say a special thank you to our presenting sponsor, Carroll House Furniture. Thank you also to Stray Dog Institute and to Kat Koshkin and Patrick Cleary for your generous support of the conference. With me today, our wonderful panelists we'll be hearing from. We have Felix Ivanger, Senior Research Fellow at Max Planck Institute for Comparative and International Private Law, who will be discussing the representation of animals in legal proceedings across European jurisdictions. We also have Yvonne Guerrera Munchonji, founder of Animal Advocates International, who will be discussing the role of animal law in engaging stakeholders in Zimbabwe. Last but not least, we have Maureen Lacier, Executive Director of International Center for Animal Rights and Ethics, who will be discussing the emergence of animal harm in France and also a comparative analysis of legal protections for animals in disasters in North America. With that, I will pass it over to Felix to get us started.
Okay, thank you so much for the kind introduction. I will today speak about the representation of animals in different jurisdictions. Speaking of representation, I am myself acting today in kind of a representative capacity, as I am presenting findings of the research group AJA, Access to Justice for Animals, which currently has the following members from various jurisdictions across Europe. Our member Maureen, who is listed here, is also present on this panel and will later address specific developments in France. So at the beginning of July, we organized a conference in Hamburg where we assembled experts from 25 European jurisdictions to compare national mechanisms for representing animals and to identify potential routes of harmonization, especially an Aarhus Convention for Animals, which I will explain later. First, I would like to give a comparative overview of the representation mechanisms that are in place in the countries we examined. I will then zoom in on 4 jurisdictions with characteristic features, and building on that, I will review some findings again in a bigger picture. Let me first clarify what we mean by representation of animals. You can distinguish between various forms of representation depending on the context, especially legal representation, political representation, and social representation. Of course, these forms overlap to some extent, but also have their distinct features and challenges. While there are many debates on political representation of animals and social representation is a completely different issue, I will focus today on legal representation. That means the representation of animals in legal proceedings, especially in court proceedings. And representation is understood here in a broad sense, referring not only to legal acts in the name of animals, but generally to any legal step taken in the interest of a more or less identifiable group of animals or a specific animal. If we now have a look at the map, we can already derive some interesting findings. I have marked here the jurisdictions from which we have received input for AJA in different colors, which indicate some key characteristics of the representation mechanisms in place according to the legend that you can see on the left. Generally and traditionally in European, or at least in continental European jurisdictions, standing requirements are very narrow and usually only allow you to act in your own interests, and only qualified and legally protected interests are relevant. In the map here, dark green are countries where NGOs can represent animals for at least some purposes of administrative law, but not in other areas of law. So these are Germany, Hungary, and Slovenia. France, bright green here, is a unique case of representation by NGOs in criminal law only. As mentioned, you will hear more about that from Marine. Then there are several yellow countries where NGOs are able to act for animals in more than one area of law. So a progressive example are the Netherlands, where administrative and civil proceedings are possible in quite a flexible manner. So far, we have seen representation mechanisms by NGOs, where NGOs are their representatives. Another model is the appointment of a specific person as general representative. Currently, this possibility is most advanced in Austria, where so-called animal ombudspersons are appointed. This office of ombudsperson is also known in some other jurisdictions, but usually involves no binding powers or is of rather political nature. Quite well known is the former institution of the animal prosecutor in the canton of Zurich in Switzerland, which, however, does not exist anymore. In all the countries that are marked gray, no special representation mechanism has been reported. There, the traditional means remain as the sole options, be it the owner who can represent the animal in some way within the property paradigm against harm inflicted by someone else, or be it the authorities who are tasked with enforcing animal welfare legislation, but are not really representatives of animals committed to their interests only. So for the overall picture, we can make two observations here. First, the legal landscape is quite fragmented. Second, countries that have some sort of representative mechanism mostly entrust NGOs with this task. With regard to 4 paradigmatic jurisdictions, we can now look a bit deeper into the details of the various models. So first, Germany. In Germany, the fragmentary impression continues. 8 states of Germany, that is exactly the half, have enacted legislation on representative actions that can be launched by NGOs. A 9th state, which is marked in bright green here, has abolished such legislation in 2018. While there are considerable differences in the details of these statutes in each state, they share some common features regarding the who, the what, and the but of these representative actions. As to the who, NGOs have to pass an accreditation procedure with the government and prove their commitment to animal protection as their statutory purpose. What can they do then? The representation is limited to administrative law and entails 3 basic rights. The NGOs have access to information, including inspection of administrative files on proceedings within the scope of animal welfare legislation. They can participate in the administrative proceedings by filing applications or stating their legal and factual views. And importantly, they can appeal administrative decisions before the administrative courts. However, the scope of application of these rights is quite limited to specific groups of animals, specific types of animal use, and specific procedural avenues, while others are excluded. In practice, these promising options fall short in several aspects. The NGOs have very limited time, mostly a few weeks, to raise issues in a proceeding. If they do not raise the issue in time, they are barred from invoking it in further stages. Furthermore, information requests are often denied by the authorities on grounds of alleged confidentiality or trade secrets, for example. And enforcing access to information would cause further delays, adding to the time pressure on the NGOs. Regarding court proceedings, a big hurdle are the high costs, which can amount to tens of thousands of euros for an NGO. Turning to the Netherlands, we see a similar approach with considerable differences in the details. The representatives are again NGOs that can prove their commitment to animal protection. Similar to the German legislation, they can participate in administrative proceedings by filing so-called enforcement requests, asking the authorities to enforce animal welfare legislation in a particular case. If the authorities then fail to comply with the request, the NGO can appeal this negative outcome before the courts. Beyond the options we have seen in Germany, NGOs in the Netherlands can also pursue civil litigation against private individuals, such as animal exploiting companies. They can, for example, rely on tort law and request a company to cease and desist from certain prohibited practices. This has been done in recent times by the organization Dier en Recht, whose logo is displayed here. And while these possibilities have been acknowledged for a long time, recent legislative changes have created some uncertainty about the procedural requirements of this framework. The scope of substantive law, however, that can be invoked is not limited in the Netherlands. The third country with a very characteristic representation mechanism is Austria, where in each state an animal ombudsperson has been appointed by the state governments. NGOs cannot represent animal interests in Austria. This ombudsperson, on the left is a picture of Eva Percy, who holds the office in Vienna at the moment, has the status of a party in administrative proceedings, entailing access to the files and the right to submit applications. She can also appeal the decisions of an authority before the administrative courts. And this right is much broader than, for example, the German representative actions of NGOs and entails any violation of the Animal Welfare Act. Beyond administrative law, the ombudsperson has also access to information in criminal proceedings, but no further rights or status in this kind of proceedings. The office is financed by the government, and its institutional character has some advantages over the representation by NGOs. On the other hand, the ombudspersons have only small teams with limited capacities, and they have difficulties to handle a large number of cases or more complex cases. Also, there is some discretion in deciding which proceedings the ombudsperson joins, and accordingly, the role is interpreted differently across the various states of Austria, with some being more active than others. Lastly, and just shortly, I want to mention the model that existed in Switzerland in the canton of Zurich, where an attorney was appointed by the government as prosecutor on behalf of the animals in criminal proceedings. The model was very innovative, providing for automatic conveyance of information about investigations that are ongoing to the animal attorney, then also vesting him with the rights of a victim in criminal proceedings, allowing him to apply for the production of evidence, to interrogate the accused, and to appeal judgments. Due to unfortunate circumstances, the office was abolished in 2010, with Antoine Goetschel here on the picture being the last animal prosecutor. And it was also limited to criminal proceedings, as I mentioned. So to summarize, we have encountered different entities who can fill the role of a representative. Something like a guardian would be a further option that is, however, not in place in any country at the moment. We can further distinguish different areas of law that are covered by a representation mechanism, and different rights and options a representative has at hand. All in all, it is critical to have a clear legal basis to guarantee the necessary resources of the representatives, to ensure the independence of the representative from state authorities, and to set incentives for the representative to become active, to intervene in particular cases. So lastly, and just very briefly, I want to speak about the Aarhus Convention as a potential model for harmonizing now these different approaches in the jurisdictions that I have laid out. The Aarhus Convention is an international instrument, an international treaty, which entered into force in 2001 and rests on three pillars being applicable to environmental law. So not animal law, not animal protection law in any sense, but in the first place only environmental law. And the three pillars that it rests on are access to information, participation, and access to justice. So the right to go to court in administrative proceedings. So this sounds quite familiar, and these rights are granted to NGOs. And this sounds quite familiar because some of these elements we already encountered when talking about the representation of animals. This is why the Aarhus Convention could be a suitable model for harmonizing the different approaches to animal representation in Europe, or maybe also elsewhere, or in a broader area. Of course, some questions still remain that would need to be answered regarding the scope, which animals are covered, for example. It cannot be maybe every small company under the treaty. That would not be agreeable maybe for some states. Then some leeway would have to be left for the implementation by different states. And besides the NGOs, the question is whether this model of ombudsperson we've seen should also be taken up here, because it is not an alternative really to NGOs, but rather complements the function of NGOs. And lastly, some compliance mechanisms would need to be set up. With that, I thank you very much and look forward to our discussion, where we can maybe go deeper into some of the points that I just briefly touched on. And I'm always happy if you have some suggestions from your jurisdiction. If you just contact me directly, you can see my details here. Thank you very much.
Thank you so much, Felix. We will now hear from Maureen.
So thank you very much for having me. Today I have the pleasure of examining and discussing a concentrated line of criminal cases from the north of France in Lille in 2024 and 2025, in which judges awarded a distinct civil head for the animal's own harm, in French préjudice animalier, in severe cruelty cases involving companion animals. So 3 questions will frame what follows. First, do these rulings advance recognition of animals' own legal interests in French law, such that an animal can be the victim of a crime and can suffer legally compensable harm? Second, if so, is this a limited assignment of passive incidence of personhood using Corky's terminology, or is it mostly symbolic within current statutes? And third, how might this practice diffuse beyond legal through judicial decisions, targeted legislation, and NGO advocacy, and ultimately beyond companion animals? So with the questions on the table, I will lay out the legal anchors that we will rely on today. So 4 legal anchors structure these cases. 1, the criminal offense is cruelty to an animal. 2, civil reparation can be awarded inside the criminal case via the attached civil claim. 3, standing by representation, which is authorized for animal protection NGOs who may appear as civil parties. And 4, the 2015 reform of the Civil Code, in particular Article 515.14, which recognize animals as sentient living beings, providing an interpretive lever to take the animal's interest seriously without having to declare legal personhood. And as you can see on the slide, it's not exactly sentient beings, but living beings endowed with sensitivity. So let me expand for a moment on why the 2015 reform matters here. So Article 515.14 did not create animal personhood, but it changed the lens. And by acknowledging animal sentience, it legitimizes judicial reasoning that personalizes the animal's interest when identifying what harm is being repaired, even though the property regime remains in place. And that clause is the hinge that makes what I call repair without personhood current in French law. So with that framework, I will turn to the facts from Lille and the 5 cases in which the court applied the anchors that we explained before. So let me walk you through the cases. All 5 cases involve egregious intentional violence against companion animals before the Lille Criminal Court, Tribunal Correctionnel de Lille. And in each case, Maître Gratier-Ladode represented the Civil Party Association, Ligue de protection des animaux du nord de la France. So in the very first case, this case concerned Lana. Lana was a young rescued cat, and the defendant, claiming that the cat had scratched his partner's autistic child, repeatedly beat Lana with a wooden slat, chased her as she tried to escape, then dumped her body in the building's bin. And a vet report confirmed injuries consistent with multiple blows. So the court convicted under Criminal Codes Article 521.1, cruelty to animals, imposed 8 months suspended and a permanent ban on keeping animals, and crucially, for the first time as a separate head, awarded 100 euros for the animal's own suffering, paid to the association acting by representation, distinct from the association's moral harm and costs. Then, about a year later, we had Lino's case. So Lino was a 4-month-old kitten drawn by his own owner. And this time the court sat as a 3-judge chamber and again awarded 100 euros for préjudice animalier. We had Buck's case, so our third case. During a violent domestic dispute with 2 minors present, the defendant grabbed Buck, a staff Malinois cross acquired only hours before the event via social media. And as Buck fled down the stairs, the defendant pushed him and then killed him with a butcher's knife and threatened his partner afterwards, telling her, "Next time it will be you." So the court imposed 30 months firm imprisonment, a definitive animal ownership ban, and 1,500 euros for préjudice animalier. and 500 euros for the NGO's moral harm. So this is a non-symbolic jump in quantum. Then we had Savi's case. The police responded to neighbors hearing blows and a dog crying. They found the owner drunk, blood on the floor, 3 terrified animals, and Savi, an American stuffed puppy, hiding behind furniture. So the vet noted bruising, missing teeth, blood in the mouth, and bloodshot eyes. And the owner admitted striking Sabi, including to the head, to correct him for selling the apartment. So the court convicted and ordered a mandatory training program, 5-year bans with immediate enforceability, and 200 euros for préjudice animalier, again, before the same court. And finally, Elliot's case, the last one in date. So the defendant, annoyed that their cat, Elliot, had soiled outside the litter box, smashed him against a piece of furniture, then trampled him, put his body in a bin, and assaulted a police officer who came to arrest them. The court convicted for offenses including severe cruelty causing death, imposed 8 months suspended and definitive bans with immediate enforceability, and awarded 500 euros for préjudice animalier. So all 5 were companion animals, and the cruelty is severe, with consistent separation between animal-centered harm, NGO moral harm, and the costs. And the amounts show calibration of the amount in light of severity, duration, and death, rather than a fixed token. So now that the facts are clear, let me define what animal-centered harm is and what it is not. So when I speak about préjudice animalier in French, I mean a distinct head of damage for the animal's own suffering and integrity. It is not the guardian's affection loss and not the NGO's mission harm. Those are separate heads, and the individual animal is the unit of analysis. So the next question is how all of this fits within civil liability. And interestingly, French scholars identified 2 routes that make animal-centered harm intelligible under the civil code. So route A is the autrui route. So in light of the animal sentience clause, a court can treat the animal as the relevant other harmed. So harm to the animal is directly repairable. And route B is the harm-centered analog. So by analogy to ecological harm, liability can be organized around the existence of a protected non-human harm, even when it's not framed as harm to a human claimant. So building on those roots, a 2022 article arguing for pure animal harm, which also means préjudice animalier, proposed a procedural architecture that in insight looks prescient. And the authors argued that traditional actions were ill-suited to repair the animal's own harm because they centered on the owner or the association. And they proposed recentering the action on the animal's interest using either route A or route B, and designing the procedures that remedies generally serve the animal. So in other words, this architecture existed in doctrine before Lille. So what Lille does in practice looks very much like a special purpose action, in French, action attitrée. And in every case, animal-centered reparation flows through an authorized NGO acting as civil party in the criminal proceeding. So the judges then keep the heads distinct: animal-centered harm, NGO moral harm, and costs, and they calibrate the amount for the animal's harm to the gravity of the facts. So that is the skeleton of a special purpose action, a defined vehicle that carries the animal's own interest inside an existing procedure without ever having to declare animal legal personhood. And the reason I stressed the special purpose action is simple. That's because it translates Lil's case by case success into a current template that other courts can adopt without touching legal personhood that may, for the time being, still scare policymakers and judges. So with the civil side clear, let me return to the criminal law lens and the status of the animal as victim. So in these files, the material victim of the cruelty offense is the animal, while procedurally the civil claim is carried by representation. And this proxy model allows the court to repair the animal's own harm within the criminal proceeding without granting the animal independent party status. And law routinely uses representation for beings without capacity. This is a familiar solution applied in a new context. And that practical picture connects directly to theory and specifically to Gorky's bundle theory. So for the theorists in the virtual room, in Gorky's terms, legal personhood is a bundle of incidents. So some are active, legal competencies and capacities, others are passive, like being a crime victim and having one's harm redressed. And no single incident is necessary or sufficient. And what we see in Lille is the assignment of passive incidents only. The animal counts as the victim, the animal's own harm is repaired, and representation carries the claim. So there is no ground of active incidents, such as legal agency or the capacity to sue in the animal's own name. And in French doctrinal terms, this also aligns with centre d'intérêt, personalizing the interest and externalizing its exercise through a representative. And why does it make sense? Why does it make legal sense to repair the animal's harm at all? Interest theory also gives a clean answer. So on interest theory, a right tracks a duty whose breach typically sets back the rights holder interest. And anti-cruelty duties are for the animal's own sake. So when breached, the animal's interests are set back. So that is the legal sense of préjudice animalier. It repairs the animal's own setback. So this is not a semantic repackaging of someone else's loss. It is a legally intelligible head of harm. So a final theoretical lens helps frame this pragmatically, and that is quasi-personhood. Fernandez describes quasi-property and quasi-personhood as a way to work within familiar categories while acknowledging that animals already trigger duties and enjoy some protections. So the point is to expand protection without forcing an all or nothing personhood fight. And in companion animal cruelty, this is both accurate and workable. So let me step back and ask, why does it matter that all 5 cases arose in Lille? France, as a reminder, is a civil law system with no stare decisis. So 5 concordant first instance rulings from the same court are persuasive, but not binding. However, a cluster like this works as a kind of jurisprudential laboratory. So you see alignment between the prosecutor's office, a receptive bench, and NGOs acting as civil parties. And they also show calibrated quantum rather than a fixed token. The appeal path is the Court of Appeal of Douai, then the Cour de Cassation. And until we have published appellate reasons, there's a risk of postcode justice. And at the same time, we need to be cautious about scope, because how far does this go? These rulings do advance the recognition of animal interests. Courts name the animal as victim and repair the animal's own suffering. They also depart from a strictly anthropocentric victimhood frame without overclaiming a revolution in status. but they are limited. So far, only companion animals, extreme cruelty, and one jurisdiction. That is the easiest terrain for recognizing animal-centered harm. So we should be careful about extrapolating to other species or categories of animals or even industrial contexts without appellate or legislative guidance. So the recognition is real, but at present it is still narrow. So how does this spread from a promising local practice to a stable national baseline? There are three practical paths. The judicial one, more first instance uptake, recent appellate decisions from DOE, and eventual cassation guidance. Legislative, enact a special purpose action for animal-centered harm, specifying who can sue, in-kind priority for reparation, earmarking, and separate heads without having to confer legal personhood. And comparative scholarship also supports a gradualist route, rights and incidents first, label later. And finally, advocacy. NGOs like the Ligue de protection des animaux du Nord de la France embed consistent pleadings, provide evidence on severity, duration, sequelae, deaths, and press for publication of reasons. So let me gather the central point before we finish. This shows that French courts can repair the animal's own harm now using existing texts. All of this without declaring animal personhood. So the task is now consistency, appeal level reasons, publication of first instance holdings, and if necessary, narrow codification that defines the head and list calibration criteria. In Kurki's terms, these judgments assign passive incidents while leaving active ones unassigned. And in Fernandez's terms, this is quasi-personhood in action, pragmatic, legible, and incremental. And French scholars in 2022 effectively anticipated this architecture by recentering the action on the animal's interest and by designing the procedure to make remedies genuinely animal-centric. So I close with a few questions for our discussion. About standing, if courts can repair via representation, what is the principled limit to denying independent standing in narrowly defined contexts? And regarding scope, should animal-centered reparation extend beyond companion animals to all animals protected by the cruelty statute? And on what thresholds? So thank you for your attention. You can find all references on these slides. And if you'd like to continue the conversation, please connect with me. We're also inviting contribution to the Journal of Animal Rights Law. So also please connect with me, and you can follow iCare for our courses and seminars, update on research and advocacy, and collaboration. Thank you very much for your attention, and back to you, Elisa.
Thanks, Marine. That was really great. And now we will hear from Yvonne.
Thank you, Alisa, and greetings, everyone. I will speak on the role of animal law and engaging stakeholders in Zimbabwe. And allow me to start sharing my screen. So Zimbabwe is a country that is in Southern Africa, and the population of Zimbabwe is approximately 17.2 million people. We are a small country as compared to the other countries. However, the agriculture forms the backbone of the economy, and our rural livelihoods depend on heavily on livestock and wildlife. So in that scenario, the role of animal law is not just a legal concern, but it is a matter of social justice, environmental sustainability, and also public health. I'll move on to the overview of existing legislation that we have in Zimbabwe. So like any other jurisdiction in Zimbabwe, we also have the Prevention of Cruelty to Animals Act. And this is the primary legislation that we have to criminalize cruelty. We have the Parks and Wildlife Act, which is a piece of legislation governing the treatment of wild animals including hunting quotas, poaching penalties, and the management of national parks. While this act is focused mainly on conservation, its provisions against illegal hunting and trade indirectly reduce animal suffering. We also have the Public Health Act, and this one provides regulations around abattoirs or slaughterhouses and meat inspection. While it is focused on human health, the Act also imposes standards that can affect animal welfare at the time of slaughter. Then we have the Animal Health Act, and this one regulates the prevention of diseases and also the disposal of deceased animals. Then we have the Animal Health National Animal Research Ethics Committee regulations of 2021, and these regulations regulates how people should conduct research on animals, and one must have a research ethics certificate that is commissioned by the committee. Then we also have municipal bylaws, and these are enacted through local governments, and they often govern stray animals, dog licensing, and the operation of facilities like pet shops and breeding kennels. And last but not least, I will also mention briefly the Scientific Experiments on Animals Act, and this one regulates how experiments should be done. And this one also includes the 3 R's, the alternatives like replacement, refinement. All these are included in this act, and that if anyone who is conducting any experiment must mitigate pain on animals. So yeah, this is what we have in Zimbabwe. And animal law is actually a tool that we have for enforcement, because the law establishes a baseline for how animals should be treated, and they serve as deterrent, a threat of prosecution as they provide for fines, and imprisonment is intended for individuals or corporations that are engaging in cruel practices. And animal law actually empowers authorities that we have in Zimbabwe, like the Zimbabwe National Society for Prevention of Cruelty to Animals, which have unique police powers under the Act, and the Zimbabwe Republic Police to intervene, investigate, and prosecute cases of animal cruelty. So in essence, the law helps to shape societal norms. They send a message that animal suffering is a serious issue and a concern of the state, thereby promoting a culture of compassion and responsibility. So the legal framework that we have allows for the lawful seizure of animals from situations of extreme suffering, and empowers organizations like the Zimbabwe National Society for Prevention of Cruelty to Animals Act to provide care and seek new homes for animals that are being ill-treated. However, while Zimbabwe's animal protection laws clearly outlined on paper in black and white, enforcement remains a significant challenge due to a lack of resources, especially for farmed animals. When we talk of wild animals and companion animals such as dogs, enforcement is good there. But when we talk about farmed animals, it's not good. There's a challenge there. The legal framework is fragmented, and despite its existence, the reality on the ground is that implementation is inconsistent and often lacking. I will mention the outdated legislation that we have. For example, the Prevention of Cruelty to Animals Act. It does not adequately address modern intensive farming systems such as battery cages, also things like puppy mills, or the complex ethical issues surrounding wild animal captivity, all that is not included. And also, sentience is not explicitly recognized. Actually, animal law in that sense is actually law. It's like there are insufficient penalties in the Prevention of Cruelty to Animals Act. And we also have cultural and socio-economic factors where people prioritize their livelihoods over welfare. For instance, you'll find that a farmer will want to have laying hens in battery cages so that they get more eggs and earn more income through selling of eggs at the expense of the laying hen. So it's more on livelihoods, economic benefits, as opposed to animal welfare. And we also have lack of awareness, and we have wildlife specific issues. Here I'm talking about human wildlife conflict. This is also a challenge. For instance, where elephants destroys crops for farmers, you find that the communities or the farmers who want to retaliate to the elephants in a cruel manner, maybe by getting some snares. At times, they kill the elephants because of human wildlife conflicts. So in as much as we have challenges and limitations, I've been actively engaging stakeholders that we have in Zimbabwe to drive change. I've, for instance, partnered with the Ministry of Agriculture through a memorandum of understanding to raise awareness and train veterinary officers and agricultural officers on animal law. This helps as they will also educate the next person as they go into communities that they work with farmers. They also tell them about the existing laws that we have. I've also engaged rural district councils through facilitating workshops and delivering presentations to integrate animal laws into communities and local governance. And I've also done community outreach and reaching to traditional leaders through delivering education sessions on animal law and farming cooperatives. I've also done community outreach where I've delivered seminars on animal law and created animal welfare clubs in high schools where I constantly teach students about the laws that we have to protect these animals. And as they hear and learn about animal laws, they also take the message back to the communities that they come from and also to their parents. So while we have the challenges, opportunities to advance animal law in Zimbabwe still exist. For instance, we can still develop umbrella animal welfare legislation to unify fragmented laws to cover like all the other animals that are not covered in other legislations like the Parks and Wildlife Act that covers wild animals. We can have an Animal Welfare Act that is comprehensive and will cover all animals, including farmed animals and companion animals that are already covered. And we can advocate for inclusion of fish welfare in the upcoming fish welfare bill, and also talking about the Prevention of Cruelty to Animals Act. We can also push for the bill that we have in the pipeline, the amendment bill, to pass through the stages, the parliamentary stages. And we can also build community-led monitoring network to report abuse. And we can also integrate law into local governance and agricultural extension programs. And we can still introduce animal law modules in veterinary curriculum. And we can also position animal welfare within the One Health frameworks to link human, animal, and environmental health. And we can also still leverage global networks for training and policy change. So in conclusion, the future of animal law in Zimbabwe is not just a legal journey, it's a conclusive movement towards justice, compassion, and sustainability. And together, we can build a compassionate and sustainable Zimbabwe. Thank you. I'll hand over back to Alisa.
Great. Thank you so much, Yvonne. Next, we will hear from Maureen again.
Thank you. Thank you very much again. Happy to present on this second topic. So when Hurricane Florence drowned millions of farmed animals in North Carolina, and when British Columbia's floods killed hundreds of thousands more, one thing became clear: our disaster laws were never written with animals in mind. Across the US and Canada, animal protection in disasters remains fragmented, uneven, and often absent. So today I will present our preliminary findings for North America from our global comparative research project, examining where the law protects animals in disasters, where it does not, and what reforms are needed. Scholars such as Best argue that disasters expose the systemic failures of existing legal frameworks, leaving animals highly vulnerable when disasters hit. And Thompson further shows that protecting animals in disasters benefits human evacuation compliance, public health, and long-term recovery. This scholarship underlines why our research on legal protections for animals in disasters was urgently needed. A few words about iCare before we dive in. iCare is dedicated to advancing the legal recognition and protection of animals' fundamental rights. We work across 4 key areas: research, producing comparative studies that inform legal and policy reform; education, including online animal rights courses, seminar series, and capacity building for advocates and practitioners worldwide; advocacy, translating research into actionable policy change at national, regional, and international levels; and strategic counsel, supporting NGO partners, institutions, and governments with legal expertise and tailored recommendations. Our vision is a world where animals are recognized and protected as sentient beings in law, with rights protected and respected and enforced across all levels of governance. So this analysis forms part of a global comparative study of the protection of animals in disasters, carried out by an international team of volunteers. And for each jurisdiction, we reviewed federal or national legislation and state, provincial, or territorial instruments. We coded each source for inclusion of animals, categories of animals covered, phases of the disaster cycle, legal form and enforceability, and underlying rationale or grounds for protection. And importantly, we evaluated the law as written, not its implementation in practice. International law defines a disaster as a serious disruption causing widespread human, economic, or environmental losses that exceed local capacity to cope. And our analysis tracks protections across the full disaster cycle. So preparedness, that is planning, early warning, capacity building; response, that is immediate action during the event; recovery, that is restoring safety, livelihoods, and service after the event; and mitigation, meaning risk reduction and future prevention. So this framework allows us to assess not only whether animals are protected, but also when during the cycle protection applies. And scholars highlight that focusing on preparedness and response alone leads to repeated failures. Risk reduction, recovery, and long-term planning remain legal blind spots in many jurisdictions. So this supports our findings that recovery and mitigation phases are severely underdeveloped, as you will see. So today I will present the findings for the United States, findings for Canada, compare the two systems, review reform recommendations, and conclude with what comes next. So in the United States, we analyzed about 300 disaster-related instruments, and only 96 of them, about 1 in 3, explicitly mention animals. And among these, companion animals appear most often, in over 84% of the text explicitly mentioning animals. Service animals come next at about 68%. Livestock appear in roughly 65%. And then wildlife in only 50% of the text explicitly mentioning animals, and captive wildlife even worse in barely 6%. And every one of those 96 texts covers preparedness. Most also cover response, but recovery appears in only 1/3 and mitigation in just 5%. So we see a clear pattern, strong coverage before and during disasters, but very little attention to what comes after, or to reducing risk for the future, and that's only speaking about to the 1/3 mentioning animals at all. And where animals are included, the law is strongest on evacuation and sheltering logistics. So co-evacuation of people and their animals, designation of pet-friendly shelters, and identification and reunification mechanisms. But 3 major gaps persist. Wildlife and captive wildlife are rarely mentioned with enforceable duties. Animals in research facilities are absent. And recovery and mitigation phases lack clear legal obligations. And the overall picture is frontal-lead protection that ends once immediate evacuation needs are met. And this structure reflects the PETS Act that was passed after Hurricane Katrina, which amended the Stafford Act to require animal-inclusive state and local emergency plans. So when Katrina hit New Orleans in 2005, thousands of residents were forced to leave their companion animals behind because no provisions existed for animal evacuation. And nearly 150,000 animals died, and almost half the people who refused to evacuate did so because they couldn't bring their companion animals. And public outrage over scenes like the boy sobbing as his dog Snowball was taken from him led to the PETS Act, requiring states to include companion and service animals in disaster planning as a condition for federal funding. So FEMA guidance and the National Response Framework operationalize these requirements, linking them to funding eligibility and policy standards. And the result is that preparedness and response phases dominate, and recovery and mitigation remain largely unlegislated. Systematic reviews confirm that people will risk or refuse evacuation rather than abandon animals when no protection exists. So this is not just an animal welfare issue, but a predictable public safety problem. Some states illustrate best practices within this framework. Oregon mandates sufficient evacuation shelters for companion animals and identification systems for reunification. Louisiana explicitly requires the humane evacuation, transport, and sheltering of animals. Or Florida obliges counties to designate at least one pet-friendly public shelter. Yet, no states combines multi-phase coverage with explicit welfare duties for all animal categories. Moving to Canada, we analyzed 20 instruments, and 9 of them include animals, which is about half. The emphasis falls on livestock and farm and agricultural animals, and companion animals appear inconsistently, while wildlife and captive wildlife almost never. And like the US, most laws cover preparedness and response, with recovery and mitigation phases underdeveloped. And most provincial statutes grant evacuation and care powers for animals during emergencies. But the British Columbia's Emergency and Disaster Management Act of 2023 goes further. It mandates animal-inclusive local plans, authorizes evacuation of people and animals together, and requires adequate care and protection for evacuees. Elsewhere, provisions remain largely discretionary and front-loaded. So across the board, we see the same legislative gaps: no federal driver equivalent to the US Pets Act, wildlife in captive wildlife rarely mentioned, recovery and mitigation phases largely absent, and companion animal safeguards uneven outside British Columbia. So turning to the provincial level in Canada, one statute clearly stands out: the British Columbia's Emergency and Disaster Management Act, adopted in 2023. But elsewhere, the picture is much weaker. Provinces like Newfoundland and Labrador and New Brunswick do authorize the evacuation and care of animals, but these provisions are usually framed in discretionary language. Officials may act rather than must act, and the focus often falls on livestock rather than companion animals or wildlife too. And comparing the two systems, the contrasts are clear. In the United States, federal law, especially the Pets Act, creates a national framework that drives states toward including companion and service animals in emergency planning. The result is a people-centered model with relatively consistent coverage for those animals across many states. By contrast, in Canada, there is no federal equivalent, so provinces legislate independently, and the focus historically has been agriculture-centered. British Columbia's 2023 Act is the exception, the only province moving toward a multi-phase animal welfare inclusive model. But both countries neglect wildlife, captive wildlife, animals used in research, and post-disaster phases. And the impact is devastating. In North Carolina's Hurricane Florence, millions of farm animals drowned, and in Canada's record 2023 wildfires, millions of wild animals likely perished, but no official counts exist. These figures show why stronger laws are urgently needed. And as Best notes, animals' legal invisibility stems partly from their property status in law, which fragments responsibility across owners, responders, and governments. And this helps explain the systemic underprotection and underreporting revealed in our findings. Because when we look at why animals are protected, most US and Canadian provisions protect animals for instrumental reasons: to protect human safety, health, or economic assets. Some laws, like Louisiana, Texas, or British Columbia's, use mixed language, adding terms like humane evacuation or adequate care and protection, suggesting at least some concern for animals themselves. But we found no instrument in either country that grounds protection primarily or exclusively in animals' own interests. So based on our findings, reform must tackle 4 things at once: who is protected, when protection applies, how binding it is, and how it is operationalized. So first, laws must name all animal categories, not only companion or service animals, but also farmed animals, wild animals, and animals used in research. Second, they must cover all disaster phases. Too many laws stop at preparedness and immediate response, but we need recovery measures, such as veterinary aftercare, reunification timelines, long-term placement safeguards, and mitigation, including animal-inclusive hazard mitigation, plans, and risk mapping for farms, shelters, zoos, sanctuaries, and research facilities, for as long as they unfortunately exist. Third, turn plans into binding, enforceable duties. No more may language. Assign a lead authority, attach funding eligibility, and require reporting to create real accountability. And finally, operationalize delivery. So guarantee pet-friendly shelter capacity, set up ID and reunification systems, plan for veterinary research capacity, require wildlife triage protocols, and impose a duty to plan on zoos and research facilities. And because what gets measured gets managed, count animals as victims, publish after action numbers on evacuation, sheltering, veterinary care, reunification, and deaths by species or category of animals. These steps are realistic, evidence-based, and directly address the gaps we've documented across the US and Canada. So before I conclude, a quick look at what comes next. We are currently testing a global ranking system that will score every jurisdiction's legal protection of animals in disasters using the same methodology across federal and unitary systems alike. And our goal is to produce a global map showing exactly where animals are legally protected in disasters and where they are still left out. Because we want this to be robust and credible, we're first testing the rankings on a wider set of countries. So that's why we're not sharing US and Canada scores today. But once this work is complete, the global map will be launched to show the worldwide picture and identify both model jurisdictions and urgent gaps for reform. So to conclude, from Katrina to Fort McMurray, from North Carolina's farms to BC floods, the evidence is clear. Law in both the US and Canada remain fragmented, with major gaps for wild animals, farm animals, and laboratory animals, and post-disaster recovery and mitigation phases. When laws exist, as with the Pets Act or BC 2023, and when funding, planning, and enforcement follow, animal lives are saved. But where laws are absent or weak, the suffering of animals is immense, but remains invisible, uncounted, and unaddressed. Animals are victims of disasters too, yet our research shows they are still legally marginalized. Stronger, enforceable multi-species, multi-phase disaster laws are not only possible, but urgently needed to ensure animals are protected before, during, and after disasters. So our next step, as I said, are to complete and release a global map of disaster law protections for animals, publish a comprehensive global report with findings and policy recommendations, and collaborate with advocacy partners worldwide to push for legal reforms in priority countries where animals are most at risk. So thank you very much for your attention. If you want to learn more about our research programs, etc., please visit our website. You can follow us on social media, and we look forward to staying in touch and working together to protect animals in disasters and protect their rights worldwide. Thank you.
Great. Thank you so much, Maureen. We will now have all of our panelists come back on camera and we'll jump into a quick Q&A. So for my first question is for Felix. You referenced the Aarhus Convention on Environmental Issues as model for future legislation. Could the convention also be used as a basis for representing animals as it stands?
Well, thank you for the question. That is an issue that we intensely discussed at our conference in July, and quite different views on this were articulated. So in my opinion, it is not entirely impossible to use the Aarhus Convention as basis for representing animals, especially wild animals. But in the end, environmental protection, what the Aarhus Convention is about, is built on different premises than the protection of individual animals, and it does also not respect the intrinsic value of animals, for example.
Yeah, great. Thank you. And our next question is for Maureen on the animal harms presentation you gave. In the Lilly cases, were animals legally recognized as victims of crime? If they weren't parties to the case, how did the court still award compensation for the animal's own harm?
Yeah, thank you very much, Alisa, for this question. So practically speaking, yes, they were recognized as victims of crime, but not for procedure. So the judges treated each animal as a victim of the cruelty offense when they assessed harm, but because animals can be procedural parties, the authorized NGO represented by Maître Garcia appeared as the civil party and carried the claim. So that procedural bridge is what let the court separate the heads of the damage and award a distinct animal-centered sum in every case that is kept apart from the NGO's moral harm and the cause. So the animals are the material victims, but the NGO acts as their procedural voice. I hope that is clear.
Yes, thank you. And could this extend beyond companion animals?
Yeah, maybe. I hope so. I'm a bit skeptical and not very optimistic about that, but technically it could, because the provision, the criminal provision it relies on, includes not just companion animals, but domesticated, tamed, and captive animals. So technically it could, but companion animals clearly are the easiest terrain to award this award. So any extension, I think, would have to be cautiously framed and be also validated by upper courts, or even given legislative guidance to make sure that we have some anchor. But I think like step-by-step approach has more chances to move forward and to consolidate any expansions.
We can
It
hope.
is already a huge step forward, in my opinion.
That's great. Thank you. Our next question is for Yvonne. You mentioned that you work with traditional leaders, rural communities, and key government ministries, such as the Ministry of Agriculture. What has their response been to your outreach efforts, and what strategies have proven most effective in fostering those long-term relationships?
Thank you so much for the question. So the response from traditional leaders and rural communities and key government ministries, particularly the Ministry of Agriculture, has been encouraging and transformative. At first, I was not that hopeful, but after their response, I'm optimistic that we can still do more to protect animals through them. Since my outreach efforts, I've seen recognition of animal welfare, not as a legal issue, but as a matter of community development, public health, and also ethical responsibility. They are trying to also spread the news, the awareness to other people that have not even like attended or not participated in some of our workshops. I hope I've answered.
Yes, thank you. That's great. That
Thank
is
you.
very encouraging. Our next question is for Maureen on the disasters presentation you gave. How does the property status of animals in law contribute to their lack of protection in disasters?
Yes, tough question. Well, tough question. No, I think we all think the same in this room. So yeah, across jurisdictions, animals remain animals remain legally classified as property. I'm not breaking any news here. And this has far-reaching consequences for animals during disasters, not just during disasters, but also during disasters. And this means their interests are framed primarily in terms of ownership or economic value, rather than as sentient beings with moral or legal claims of their own. And this also leads to, as Best has argued, to fragmented responsibilities. Owners are often seen as primarily responsible for their animals' welfare. Governments and responders step in only when public health or safety or economic risk are implicated. And then the laws frequently justify protection for animals instrumentally to safeguard livelihoods or to prevent public health crisis rather than for the animal's own sake. So at times, we can rely on this anthropocentric rationales to try to advance animals' protections, but also very often this is not sufficient, and we can see that this is definitely not enough in the case of animals protection in disasters, because even when we try to take all these rationales together, you hit a wall. And for instance, in the case of wild animals, you can see that they are clearly left behind. And even if you were to try to rely on environmental or biodiversity protection for anthropocentric reasons, you still need to have a protection of animals for their own interest, for their own welfare, for intrinsic reasons. And our findings in both the US and Canada reflect this, that wild animals are clearly absent from legal frameworks because they do not fit neatly into property or economic categories. So the law just perpetuates this systemic underprotection, and animals are just optional considerations.
Great, thank you. Well, that concludes our Q&A today. Thank you so much for joining us on the Global Perspectives of Advancing Animal Law panel. Just a reminder that if you have any other questions, our panelists did leave their information, so you can contact them to ask them that. We hope you enjoyed this panel and enjoy the rest of the conference.